Good evening, everyone. Good evening, my future chartered accountants. कैसे हैं सब लोग? So today we are starting the chapter Limited Liability Partnership. Good evening, Mahi. Good evening, Alka, Abhishek. Good evening, Niru, Hardik, Pallavi, Nayan. Good evening, बच्चों. We miss you, sir. I also miss you all, यार. Good evening, Balesh, Supriya. Good evening. Uh, Good evening, Balmurugan. पता है, when I start the chapter LLP in every batch I just give the example of Tenali Rama, but this time one more thing which inspired me to take its name to start LLP. Good evening Vaishnavi, Nancy. Good evening Tameshwari. So let's start. The two lectures are uh, allotted for the topic limited liability partnership. So this story I always take in every batch, but this time one more thing, I should take its name, that is Sangam, and in fact LLP Sangam of partnership and the company, right? I'm also happy, Balmurugan sir, सही कहा ना? LLP Sangam of partnership and company. So let's start. First तो वही डिस्कस करना है वो जो all of you have already read basic concept in foundation, the LLP, the applicability of LLP. Good evening, Ankit. LLP bill was notified by the Ministry of Law and Justice on 9th January 2007, passed by the Parliament on 12th December 2008, and the consent of President of India on the bill was on 7 January 2009 and called LLP Act and came into force from 31st March 2009, and it extends whole of India including Jammu and Kashmir. ठीक है, ये बात सबको पता है. Contents of LLP Act 81 section 4 schedule. First schedule for the mutual rights and duties of the partners. Actually, the applicability of first schedule is that in those cases where there is no specific LLP deed, so first schedule will be there. Second schedule deal with the procedure for conversion of a firm into LLP. Third schedule deals with the conversion of private company into LLP, and fourth schedule deals with the conversion of unlisted public company into LLP, right? LLP Act has been amended through the LLP Amendment Act 2021 dated 13th August 2021 तक ये amendment आ गए हमारे, and I have updated all the relevant amendments in this slide, right? Good evening, Ritika. Some important points, in fact, in your practical life, these are important points. Administration Authority, the Ministry of Corporate Affairs, who will look after all the provisions of the LLP. Regulation Authority, Central Government Authority to frame the rules, notifications, and some amendments which are required for the rules, and some specific specific reasons the notification should be given. One thing you should note, the provisions of Indian Partnership Act 1932 will not be applicable for the LLP, right? Meaning and concept of LLP. अच्छा, इससे पहले तो क्लास थी आपकी टैक्स की, अंकित सर की क्लास, right? And I think the class was just before about 5:30 was closed. So मुझे लगता है थोड़ा सा टायर्डनेस तो होगी, पर डोंट वरी, बोरियत नहीं आने दूंगा मैं. जहां बोरियत आए प्लीज बोल दीजिएगा, ठीक है ना? अच्छे से पढ़ते हैं, बहुत ज्यादा टाइम नहीं लगाएंगे, बड़े अच्छे से, राइट? तो मीनिंग एंड कंसेप्ट ऑफ एलएलपी, क्या कंसेप्ट है एलएलपी का? new form of legal business entity with limited liability. One thing you should note, the liability is limited of partners, not the LLP. LLP is separate legal entity as like a company. LLP itself will be liable for full extent of its asset, but the liability of partners is limited. LLP is an alternative corporate business form that gives the benefits of both LLP, a limited liability of company, and the flexibility of partnership. This is the basic concept. Just start with the definitions. Some important definitions you should have the idea, you should learn. Good evening, Nanda Gopal ji. First definition is the address. Section 2, subsection 1, clause A provides address in relation to LLP means, in relation to partner of LLP means, if individual has usual residential address and if body corporate, the address of the registered office. Means when we are talking about the address of the partner, it means his residential address. And if we talking about the body corporate, if the body corporate is the partner in the LLP, the address of registered office is taken as the registered is taken as the address of the company or body corporate. Now, body corporate, again, an important definition for examination point of view. Section 2, clause 1, subsection D provides company as defined in clause 20 of section 2 of the Companies Act 2013 and includes LLP registered under this act, LLP incorporated outside India, company incorporated outside India. Stay on this point only. तो अभी तक हमने क्या डिस्कस किया कि बॉडी कॉर्पोरेट मींस एलएलपी एंड कंपनी, वेदर इंडियन वेदर फॉरेन, एलएलपी वेदर इंडियन वेदर फॉरेन. So 4 persons will be taken as body corporate for the purpose of LLP Act. What are those? LLP, Indian or foreign. Company, Indian or foreign. But does not include exclusively, exclude कर दिया गया specifically, a corporation sole proprietorship, a cooperative society, and any other body corporate which is specifically excluded by the central government by notification in the official gazette, right? So any of you have any doubt on this definition, please tell me. तभी आगे बढ़ेंगे बच्चों, एक एक करके चलते जाएंगे अपन. कॉर्पोरेशन सोल मीन्स सोल प्रोप्राइटरशिप कंसर्न कर सकते हैं, यू कैन से. ओके, नेक्स्ट some small definitions. Business, section 2 clause subsection 1 clause E. Business includes every trade, profession, service and occupation. Originally the definition was up to these words and occupation, but after the Amendment Act these words are added, except any activity which the central government may by notification exclude. बहुत सिंपल सी बात है, ये सब चीज इंक्लूड होगी. लॉफुल ट्रेड होनी चाहिए, एवरी ट्रेड, impliedly कह सकते हैं एवरी ट्रेड, प्रोफेशन, सर्विस एंड ऑक्यूपेशन दैट शुड बी लॉफुल, राइट. बट एक्सेप्ट स्पेसिफिकली एक्सक्लूड कर दिया गया इफ सेंट्रल गवर्नमेंट एक्सक्लूड बाय नोटिफिकेशन. If central government exclude any trade, profession, service, particular occupation by notification. Chartered accountant means chartered accountant as defined in section 2 subsection 1 clause B of Chartered Accountant Act and who has obtained the certificate of practice. One thing you should note that in this act, LLP Act, when we are talking about the chartered accountant, we are talking about the chartered accountant who is in practice. The chartered accountant who is not having certificate of practice, member है but practice of certificate of practice नहीं है, so it will not be chartered accountant for this purpose, for this act. Designated partner as defined in section 7. Entity means any body corporate and includes for the purpose of section 18, 46, 47, 48, 49, 50, 52 and 53 a partnership firm set up under the Indian Partnership Act 1932. Initially, I told you that the partnership will not be applicable, but for these specific sections, what are sections? 18, 46, 47, 48, 49, 50 and 50, 52 and 53. Entity means partnership firm all, right? सर एग्जाम में ना बड़ी प्रॉब्लम आने वाली है सर, ये सारी पॉइंट कैसे याद होंगे? सेक्शन 18, 46, 47, 48, 49, 50, 52, 53. सिंपल आइडिया, सिंपल तरीका टू लर्न दी सेक्शन, बस लिख के देख लो बाय राइटिंग. बट इवन दैट सर, we could not recall these section in the examination hall. So you and definition was asked. Then in that case, you can mention the definition in this way. Entity means any body corporate and include for some specific sections a partnership firm set up under the Indian Partnership Act 1932. For an LLP, Section 2, subsection 1, clause M, it means a LLP formed in corporate registered outside India which establish a place of business within the India. मतलब incorporate हुई इंडिया के बाहर but having place of business in India, right? यहां तक कोई डाउट? पढ़ लो आराम से. सर after qualifying in CA exam to become a CA in practice, what is additional thing to be done? Just you have to when you file the form of membership, you have to file additional form of certificate of practice, right? आपको सर्टिफिकेट प्रैक्टिस का फॉर्म अलग से फाइल करना पड़ेगा, बाकी और कुछ नहीं करना. So please give the 1 minute on this slide and any query regarding these definitions, so you can ask me. LLP liable for full extent of its assets means, Ankit Mishra is asking, but this means the LLP have to pay its liability out of its assets. जो इसकी assets है उन्हें बेच के तब बेचे तो तब liability पूरी करनी, right? Now financial year. Section 2, subsection 1, clause L. Financial year in relation to LLP means the period from the 1st April of the year up to the 31st day of March of next year. बहुत सिंपल सी बात है, 1 अप्रैल से 31 मार्च. But in case LLP is incorporated after 30th day of September of the year, the financial year may end on 31st day of the March of the next following that year. Means, if see the example number 1, if the LLP has been incorporated on 15th October 2022, the financial year may be from 15th October 2022 to 31st March 2024. And this is specifically for LLP Act, not for other act. ये LLP Act ने कहा है, इनकम टैक्स की बात नहीं कर रहे, किसी और एक्ट की बात नहीं कर रहे. So what is the purpose of this line? It means the formalities under the LLP for financial year. In this case, in this particular example, can be shifted to next year. कि भाई जो हमें फाइनेंशियल ईयर के लिए एनुअली हमें रिटर्न सबमिट करने हैं एलएलपी एक्ट में, वो हम उस साल नहीं करके नेक्स्ट ईयर कर सकते. बट प्रॉब्लम क्या है? प्रॉब्लम इज दैट द इनकम टैक्स डिपार्टमेंट से कि भैया हमें तो बैलेंस शीट चाहिए, प्रॉफिट चाहिए, हर साल का रिटर्न भरो. इवन द एलएलपी कॉर्पोरेट मार्ट, वी नीड द रिटर्न फॉर दैट ईयर because the company was in LLP was in existence in the financial year. थी भाई उस LLP फाइनेंशियल में जिंदा थी तो रिटर्न तो भरना पड़ेगा इनका, भले ही नील का भरिए, राइट? So income tax department has prescribed the uniform financial year from 1st April to 31st March of next year. In keeping with the income tax law, the financial year for LLP should always be from 1st April to 31st March for that. भैया कर ही लो यार फाइनेंशियल ईयर एंड, चक्कर में पढ़ना ही नहीं, प्रैक्टिकली की बात. एनी डाउट ऑन दिस पॉइंट? नयन पाटिल इज सेइंग सर 31st मार्च 2023 आएगा ना. अरे मेरे यार सारी रामायण खत्म हो गई. आप समझे नहीं बात को। Specifically mentioned in this clause if LLP is incorporated after 30th September. So if in example number 1 LLP was incorporated after 30th September 2022, so financial year may be the end of financial year may be shifted to next financial year, next to next 31st March. तो नॉर्मल केस में 22 में बन गई कंपनी, 23 फाइनेंशियल एंड होगा, पर इन्होंने कहा भैया अगर आपका अभी 6 महीने भी नहीं हुए हैं आपको कंपनी एलएलपी स्टार्ट किए हुए, तो आप एक काम कीजिए, फॉर्मेलिटीज आपकी अभी तक बिजनेस भी स्टार्ट नहीं हुआ होगा, तो आप एक काम कीजिए, एलएलपी का जो रिक्वायरमेंट है, एनुअल रिक्वायरमेंट है, दैट कैन बी शिफ्टेड टू द नेक्स्ट ईयर। अभी समझ में आया क्या? One question has been asked. I think I can expect the question from you people that sir, if LLP incorporated after 1st October, ITR to be filed for 6 months or after 18 months? ITR should be filed up to the 31st March 2023। 6 महीने आप 1 अक्टूबर को करते हैं, 6 महीने का फाइल करना, फाइनेंशियल का फाइल करना पड़ेगा, ये तो रिक्वायरमेंट है सर। 5th September 2023, so financial year will end from 31st 3 2024. Tameshri is saying, sir, if LLP is incorporated on 5th September 2023, so financial year will end on 31st March 2024. Absolutely right. Okay. Any other query? तो दिस 18 month पीरियड फॉर आरओसी फाइलिंग ओनली, यस, बिल्कुल बिल्कुल तो सही बात। एनीथिंग एल्स? सर इन केस एलएलपी इज इनकॉर्पोरेटेड ऑन December 1st 2024, we can shift the financial year end to 31st March 2026. Yes, absolutely right. कहना यह है कि सर अगर 1 दिसंबर 2024 में बनी एलएलपी, नॉर्मल 31 मार्च 25 में होना चाहिए, क्योंकि अभी 6 महीने भी नहीं हुए, तो क्या कर सकते हैं, 26 तक ले जा सकते हैं फाइनेंशियल को। एनीथिंग एल्स? समवन इज आस्किंग सर रजिस्ट्रार कौन पर्सन होता है? डीएम होता है। अरे भैया रजिस्ट्रार कंपनी से सेपरेट अथॉरिटी, ऐसा मत करो यार। अच्छा बताओ, थकान तो नहीं लग रही है ना, बोरियत तो नहीं आ रही? समझ आया नहीं आया बोलो फटाफट से, आगे बढ़ते हैं, क्योंकि थके हुए तुम लोग पढ़ के आए हो आज। सर आई डोंट नो हिंदी, प्लीज ओनली इंग्लिश। आई listen everyone who doesn't have the idea of Hindi, I just repeat my word what I've said in English in Hindi। मैं सिर्फ हिंदी में रिपीट करता हूँ, I just repeat in हिंदी। ऐसा नहीं है कि आई एम जस्ट गिविंग इन हिंदी ओनली, नॉट इन इंग्लिश। ओके, तो डोंट वरी, नथिंग विल बी मिस। सर एलएलपी और कंपनी में क्या डिफरेंस होता है? LLP separate person, company separate person, both laws are different, right? सर कंपनी लॉ में 1 जनवरी के बाद फॉलोइंग ईयर एंड एलएलपी में 30 सितंबर के बाद फॉलोइंग ईयर। आई थिंक यू आर एब्सोल्युटली राइट, बट प्लीज आई एम डिस्कसिंग अबाउट एलएलपी, सो प्लीज ही आस्क मी अबाउट एलएलपी, राइट? LLP is hybrid of company and partnership firm. Very good. Okay. LLP, limited liability partnership, means partnership form registered under this act. Very simple point. I think that this could not be asked in your exam ki bhaiya what is the LLP, define the what is LLP. No, I don't think. LLP agreement, a written agreement, that can be, you can say the LLP deed. limited liability partnership deed between the partner of LLP or between the LLP and its partner, which determines the mutual rights and duties in relation to LLP. Name in relation to partners of LLP means if individual is forename, middle name and surname, and if body corporate it's registered name. Name का मतलब क्या है भाई? अगर इंडिविजुअल है तो पूरा नाम, and if the body corporate registered name, right? बताओ भाई, डाउट तो नहीं है ना? अभी तक कोई आया तो नहीं? Any doubt up to this point? Partner section 2 subsection 1 clause Q. Partner in relation to LLP means any person who becomes a partner in accordance with the LLP agreement. बहुत छोटी सी बात है but important बात है. Very small definition but very important point. Partner as per the agreement means any person can be partner only as per the LLP agreement, right? Regional directors means a person appointed as such by central government for the purpose of this act or the Companies Act 2013 as the case may be. Registrar means registrar of companies, person appointed by central government and registrar and additional registrar, joint registrar, deputy registrar or assistant registrar for the purpose of this act or the Companies Act as the case may be. So you need not to go to the depth of who is the registrar, right? Someone is asking LLP is separate entity. यहाँ तो बात समझ में आती है. And partners are liable for each other. Just wait. I definitely give the answer of your query, but just wait for few minutes, right? A small LLP. This concept was inserted by Amendment Act. LLP Amendment Act. Section 2 clause subsection 1 clause TA. T के बाद ऐड हुआ TA. It means a LLP, the contribution of which does not exceed 25 lakh rupees or such higher amount not exceeding 5 crore rupees as may be prescribed, and the turnover of which as per the statement of accounts and solvency for the immediately preceding financial year does not exceed 40 lakh rupees or such higher amount not exceeding 50 crore rupees as may be prescribed, or which meets the other requirement as may be prescribed and fulfills such terms and conditions as may be prescribed. तो ये तो मैंने अभी just I have read the definition which is given in section, but one thing you should note about this definition that these two parts are at one place and this is at one place. For the purpose of declaring whether a LLP is a small LLP or not, one condition out of two should be satisfied. एक LLP स्मॉल LLP है या नहीं है, उसके लिए दो में से एक कंडीशन सेटिस्फाई होनी चाहिए, पार्ट ए एंड पार्ट बी. These 2 points are in part A and this point in part 2. So first we have whether we when we have to check whether the LLP is small LLP or not, so we should go part 1. Both conditions should be satisfied for part 1. If only one is satisfied, if no condition is satisfied, we should part A will not be there, so we should go for part 2. And part 2, if part 2 is also not satisfied, in that case the LP is not a small LLP. ठीक है. अगर क्वेश्चन आता है दिमाग में कि क्या हमारी LLP स्मॉल LLP है या नहीं है, तो हमें दो पार्ट में कन्वर्ट करना पड़ेगा, फर्स्ट पार्ट एंड सेकंड पार्ट. Two conditions in first part and they both should be satisfied for the purpose for declaration of LLP as a small LLP. But if any one condition or both are not satisfied in part 1, then we should go to part 2. So I should come firstly for part 1. What is the part 1? द कॉन्ट्रीब्यूशन ऑफ विच डज नॉट एक्सीड 25 लाख रुपीज, यहीं तक रुक जाते, स्टे ऑन दिस पॉइंट ओनली. It means LLP, the contribution means capital contribution of which does not exceed 25 lakh rupees and underline कीजिए and the turnover of which as per the statement of accounts and solvency for the immediately preceding financial year. Statement of accounts and solvency, you can say the financial statement like P&L balance sheet, does not exceed 40 lakh rupees. Two conditions should be satisfied. Capital is up to 25 lakh. Turnover is up to 40 lakh rupees of the immediately preceding financial year. Right? If turnover is more than 25 lakh rupees, turnover is more than 40 lakh rupees and capital is up to 25 lakh rupees, it means one is satisfied, second is not satisfied, then part A is not there, you should go to part B. Part B क्या कहता है वो भी आते हैं. Both conditions should be satisfied. So okay, now read the point 1 for in whole. क्या लिखा है? The contribution of which does not exceed 25 lakh rupees or such higher amount not exceeding 5 crore rupees as may be prescribed. So why, sir, it was mentioned that all such higher amount not exceeding 5 crore rupees as the case may be? Because this is the act. Act is enactment and this is properly passed by the parliament, both house of parliament, and after the consent of the president, the act becomes the law, right? But according to the act, the authority for rules is given to the central government. The central government is the authority to make the rules. So the purpose of adding these words or such higher amount not exceeding 5 rupees, that in future, presently the limit is 25 lakh rupees, but in future, because the because of inflation, 25 lakh rupees is a small amount. After some time, this limit has to be increased. So this limit can be increased up to 5 crore rupees without passing the provision in the parliament. So parliament has given the permission up to 5 crore, but this should be decided by the central government. But presently it is 25 lakh rupees and 40 lakh. If both conditions are not satisfied, then you should go for the part number 2. Part number 2 which meets such other requirements as may be prescribed and fulfill such other terms and conditions as may be prescribed. So wherever it was mentioned as may be prescribed means as prescribed by the rules. So if these two conditions are not satisfied, one or both are not satisfied, you should go for the point number 3. And if anything specifically mentioned in the rules, so and LLP satisfying those rules, it is also be considered as a small LLP. ये एक बार पढ़िए और मुझसे क्वेरी पूछिए. आई एम एक्सपेक्टिंग द क्वेरीज ऑन दिस सेक्शन फ्रॉम यू. क्वेरी आनी चाहिए इस पॉइंट पर आप लोगों की. सर LLP इज अ टाइप ऑफ पार्टनरशिप. यस यू कैन से पार्टनरशिप तो है ही. Any query on this section, on this clause? सर अभी लिमिट 25 लाख है एंड 40 lakhs है and above this it is not a small LLP. Yes, absolutely right. Sir, which type of terms and conditions talk about here in point number 3? I think these are mentioned in the rules. I am not taking these conditions. अभी ऐसा कोई लगता नहीं कोई ऐसी कोई रूल्स अभी कंडीशन प्रोवाइड की गई है. मीन सच अदर रिक्वायरमेंट इफ देखिए पॉइंट 3 क्या कहता है? अदर रिक्वायरमेंट एज मेंशन इन द रूल्स. तो अगर रूल्स में कुछ दी हुई है तो वो फॉलो करनी पड़ेगी. बट आई थिंक द इन रूल्स कंडीशन अदर कंडीशन आर नॉट मेंशन. एनीथिंग एल्स? सर स्टेटमेंट ऑफ अकाउंट इज ओके बट स्टेटमेंट ऑफ सॉल्वेंसी, दिस फाइनेंशियल स्टेटमेंट वर नेम्ड एज statement of account and solvency, because your balance sheet provides whether you are capable to solve your liabilities or not. It is called statement of solvency, right? Anything else? Sir, first one is compulsory and second and third are either or basis. No, please, 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 please. First and second. Just mention bete. First and second. ये this is or is for this is or. The or is not between 2 and 3. The or is between 1 plus 2 and 3. ये दोनों these 2 points are at one side and this third point is at one side, right? 1 plus 2 or 3. Yes, yes, yes. Sir, can we call them our financial statement? Yes, you can say. Keshav Kasak Yadav is saying, sir, clear till now 1 and 2 together or 3. Yes, absolutely right. Okay. Sir, what are those other requirements? Point number 3. You need not to go there. Okay. Sir, current year is the turnover and contribution 26 lakh after future crossing limit 5 crore and 50 crore when SLLP not present. I am not getting your query, beta. Please एक बार clear कीजिए. Tamishri, please mention clearly your query. Sir, what is 5 crore and 50 crore? What is 5 crore? I am just talking you. मैंने बताया बच्चे, just told you कि 5 crore and 50 crore allowed in the act. Your limit can be extended up to 5 crore and 40 lakhs can be extended to 50 crore without the permission in the without the passing of the proposal in the parliament, right? Central government को power दी भैया, यहाँ से तुम बढ़ा सकते हो, but if you want to go beyond that limit, permission from the parliament should be there. Sir, such limit is for the previous year or in current year. What are you saying? Please read it carefully. Everything is mentioned. The contribution up to which, suppose kya, today is the date of 8 January 2025 and now at this place you are checking whether your LLP is small or not, right? So you just take the today's date for the capital contribution and you take the turnover, you will take the turnover of the previous financial year. It means 23-24. Okay. Higher limit cross future when a small LLP become LLP. Yes, that way that LLP will not be taken as a small LLP. Swati is saying the central government has power to increase the limit up, increase it's up to the limit without getting the pass in the parliament, because this limit is already passed by the parliament. Okay. Tribunal means National Company Law Tribunal under Section 408 of Companies Act. It means if any dispute is referred to tribunal or power or tribunal is used, tribunal means it's a company law tribunal, right? One important note: words and expression used and not defined in this act but defined in the Companies Act shall have the meaning respectively assigned to them in that act. Means if any word is given in the LLP Act which is not defined in LLP Act but defined in Companies Act, so meaning can be taken from the Companies Act. LLP provision of Partnership Act will not be applicable to LLP. One more question from your side, that sir, what is the reason behind the segregating the small versus normal LLP? the reason behind for segregating the small versus normal LLP is that in case of small LLP, the legal formalities are reduced. भाई नॉर्मल जो लीगल फॉर्मेलिटीज है नॉर्मल एलएलपी के लिए ज्यादा है और स्मॉल के लिए उनमें कुछ कंसेशन दे दिए गए फॉर द पर्पस ऑफ प्रिविलेजेस टू ए स्मॉल एलएलपी. Can LLP be converted into company? No. Now the characteristics of LLP. So almost characteristics are same as that of company, right? LLP is a body corporate. It's separate legal entity from its partner. Perpetual succession. The LLP can continue its existence irrespective of changes in the partner. Death, insanity, retirement, or insolvency of partners has no impact on the existence of LLP. This work on the concept man may come, man may go, but LLP will go forever. Separate legal entity, the LLP is a separate legal entity. Criteria of LLP are the criteria of LLP alone, not from of the partner. It means the creditor cannot claim their dues from the partner. They can ask only from the LLP. Sir, same as foundation level 16 characteristics, same beta same. Actually, LLP Act भी same है ना? Because the LLP Act was also same, but in foundation basic points were given, but in intermediate because आप बड़े हो चुके हैं थोड़ा सा बढ़ा दिया गया, right? Limited liability, the liability of partners will be limited to their agreed contribution in the LLP. Mutual agency, all partners are agent of LLP alone. No one partner can bind the other partner by its act. Means for the acts of the partner, only LLP will be liable, other partner will not be liable. LLP agreement, mutual rights and duties of the partnership within an LLP are governed by an agreement between the partners. And if there is there is no agreement, the mutual rights and duties shall be governed by the first schedule of the LLP Act. Minimum 2 partners, but there is no limit for there is no maximum limit for the partners in LLP. LLP cannot be for charitable purpose. It is only for business purpose. LLP is an artificial legal person. So it can do everything which a natural person can do, except of course, it cannot be sent to jail. It cannot take an oath. It cannot marry or get divorced, nor can it practice like you are future chartered accountant. Common seal, it is not mandatory for LLP to have a common seal. Actually, common seal is made of the metal, and then when you press the common seal on the paper, the name of the LLP engraved on that paper, but it is not the mandatory requirement. This is like a signature of LLP, but it's not a mandatory requirement. In the absence of a common seal, 2 designated partners can authorize the document. Management of business, the partners in LLP are entitled to manage the business, but only the designated partner responsible for legal compliance. Firm, private company, unlisted public company would be allowed to be converted into LLP in accordance with the provisions of LLP Act 2008. Investigation, central government shall have power to investigate the affairs of LLP by the appointment of competent authority. And what are the compromise arrangements? Compromise and arrangement in the LLP, including merger with other LLP, amalgamation with other LLP, should be according with the LLP Act 2008. For an LLP, the LLP which was incorporated outside India but having place of business in India, so that LLP have to follow the rules and regulation of Indian LLP Act 2008. A foreign LLP can be a partner in LLP e-filing of document. Now the documents are on the legal document on the regarding the LLP should be, are filed on online basis in the MC21 portal. What are the advantage of LLP? यहाँ तक मेरे ख्याल से आपकी फाउंडेशन में था. Easy to form LLP agreement can be customized according to the needs of partners. It operates on the basis of agreement, no minimum capital requirement, less compliances and tax burden as compared to company, flexibility for increasing the funds. Liability of partner is limited to the contribution as made in LLP. Dissolution procedure easy as compared to company. So these were the, I think these were the course covered in the foundation also. एक बार तो पढ़िए, यहाँ तक कोई क्वेरी हो तो बताइए, फिर आगे बढ़ते हैं. कोई क्वेरी नहीं? एनी क्वेरी? Sir, LLP follows which method to prepare financial statement as per Schedule 3 or as per the partnership? देखिए, this should be followed as per the LLP Act. LLP जो rules है उनके according बनेगा. Partner section 5. Who may be the partner? An individual or body corporate? What are the body corporate? LLP and company, whether Indian or whether foreign. Individual can be the partner, but one thing you should learn, the individual who is capable to enter into the contract can be the partner. So however, individual shall not be capable of becoming part of LLP if it has been found unsound mind by the court of competent jurisdiction. He is undischarged insolvent है वो अभी presently, and he is applied for declaring as insolvent and his application is pending, he cannot be a partner. But in this case, my two questions from your side, it is not mentioned whether minor can be partner or not in LLP. According to you, whether minor can be the partner? कुछ तो बोलो बच्चों. No. Very good. सबका जवाब है no. Very good. Whether HUF can be the partner? Whether HUF can be the partner? No. Answer is no. Very good. So only individual who is capable to enter into the contract and body corporate can be the partner. Every LLP shall have at least two partners if at any time the number of partners of LLP reduce below 2 and LLP carries on the business for more than 6 months. एक सेकंड होल्ड कीजिए. If at any time the number of partners of LLP is reduced below 2 and LLP carries on the business for more than 6 months, while the number is so reduced, the person who is only partner of LLP during the time that it so carries on the business after those 6 months has the knowledge of the fact that it is a carrying on the business with him alone shall be personally liable for the obligation of the LLP incurred during that period. Please read once again. बहुत सिंपल है. If only one partner in the single partner with single partner for more than 6 months, then after 6 months, if the partner has the knowledge of the fact that he is only partner, he will be personally liable like partners in case of partnership firm. अब आती है आपकी क्वेरी. ठीक है, पूछिए. Sir, firms can be the partner. Partnership firm cannot be a partner because as per body corporate, what is the body corporate? LLP and company and individual. These can be the partner. Undischarged insolvent means the person who is presently declared by the court as insolvent. When he will pay his liabilities, inform the court. Court will check whether he has paid all his liabilities. Now he becomes the solvent. It means he is the discharged insolvent. Sir, can foreign individual be the partner of LLP? अब यहाँ पर ना at this point it was not mentioned that individual should be foreign or Indian. That is not mentioned. So in my views, foreign individual can be the partner. Sir, two LLP can become the partner definitely. Body corporate can be the partner. Any other query? Vingesh Nayak is saying, sir, after 6 months, yes, the liability of the partner, a single partner is there, and he has the knowledge of the fact that he is a single partner. The liability will arise only on the transaction which are incurred after the 6 months, right? Sir, Kasak Yadav is saying, sir, that if only partner remains, then it will not be limited anymore. It will be held personal liability. Yes, absolutely. Sir, discharge insolvent can be the partner. Yes, if he discharge, सारे गुना माफ हो गए उसके, he can be the partner. Now, designated partner. Section 7 provides. Designated partner means like director in case of company. Every LLP shall have at least two designated partners who are individual, and at least one of them shall be resident in India. So the at least two individuals should be a designated partner, and out of them one should be resident in India. कम से कम एक तो होना चाहिए. Provided if in LLP all partners are body corporate. If someone is asking, sir, whether two LLPs can be the partner, answer is yes. In this case, both the partners are body corporate, or if the case may be in which one is individual and other are the body corporate, in which one or more partners are individual and body corporate, at least two individual of the partner of such LLP, the nominees of such body corporate shall act as designated partner. Means, suppose in an LLP, two LLPs are partners, possible because they are body corporate. But in case of body corporate, in case the body corporate is partner, that body corporate has to provide the nominee who will work on behalf of that partner LLP. अगर दो LLP पार्टनर हो जाती हैं तो भैया वो खुद कैसे काम करेंगी? वो तो आर्टिफिशियल लगता है, भगवान की तरह है वो. दे आर लाइक गॉड, है पर दिखता नहीं है, राइट? So they have to provide the name of nominee. They will work on behalf of those LLP. So that nominee should be the individual, right? See the example number 2. A LLP by name SMY LLP has three partners: SI Limited, MIS Limited, YI Limited. There is no individual partner in LLP. So nominees of any two said body corporate shall act as the designated partner. तीन पार्टनर है कंपनी, तीनों कंपनी है, तो भैया तीनों का एक नॉमिनी होगा, उनमें से कोई भी दो डेजिग्नेटेड पार्टनर हो सकते हैं. LLP has three partners, one individual, Mr. X, and two body corporate, XYZ and ABC. In this case, X and one nominee of body corporate shall be the designated partner. Please read once again example number 2 and 3 and then ask me the problems. Sir, in example number 2, one company can have 3 nominees and rest is not have possible. No possible. No, 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 no. Each in body corporate should have only one nominee. हर बॉडी कॉर्पोरेट का एक ही नॉमिनी होगा, दो नॉमिनी नहीं होते. Sir, if individual is there, then in the sir, if individual is then there, he should be given the priority over nominees. Yes, definitely. This section applicable when all partners body corporate? No, no. Please try to understand the concept of that section. Two, there should be at least two designated partner. One should be a resident, and both should be individual. If there is no individual partner in the LLP, then nominees of that body corporate can be the partner, can be the designated partner. Sir, then out of these three nominees, one should be resident. Yes, absolutely. आगे पढ़ते हैं, क्लियर हो जाएगा. See, resident in India means for this purpose a person who has stayed in India for a period of not less than 120 days during the financial year. फाइनेंशियल ईयर के लिए हमें चेक करना है, तो उस फाइनेंशियल ईयर में अगर 120 दिन इंडिया में है तो वो क्या माना जाएगा, रेजिडेंट इंडिया. सी द एग्जांपल नंबर 3. There is an LLP by the name Indian Helicopters LLP having 5 partners, namely Mr. A non-resident, Mr. B non-resident, Miss C resident, Miss D resident, and Miss E resident. In this case, at least 2 should be named as designated partner, out of which one should be resident. Hence, if Mr. A and Mr. B are designated, then it will not serve the purpose. So one of the designated partner should be there out of Miss C, Miss D और Miss C. क्लियर हुआ क्या नहीं हुआ, बताओ फटाफट से. ओके, वेरी गुड. तो आगे बढ़ते हैं. If the incorporation document specifies who are to be designated partners, such shall be designated partner. If the incorporation document specifies who are to be the designated partner, such person shall be designated partner on incorporation, or states that each of partner from time to time of LLP is to be designated partner. Every partner shall be a designated partner. बहुत क्या लिखा है, सिंपली सो समझो. At the time of incorporation of LLP, if document mentioned that after incorporation these partner will be designated partner, then those partners will automatically be the designated partner on the incorporation of LLP. And after that, who will be the designated partner? As per the agreement, state which each of the partner from time to time, agar that was mentioned that each partner will be the designated partner, then every partner will be the designated partner on the incorporation. Any partner may become a designated partner by in accordance with the LLP agreement, and a partner may cease to be designated partner in accordance with the agreement. So point number one of 2, that is concerned about the status of partner at the time of incorporation. एंड दिस इज आफ्टर इनकॉर्पोरेशन. भैया इनकॉर्पोरेशन हो गया, उसके बाद तो पार्टनर कौन होगा, डेजिग्नेटेड पार्टनर कौन नहीं होगा, दैट शुड ऑलवेज बी मेंशन इन द एलएलपी एग्रीमेंट, राइट. An individual shall not become a designated partner in LLP unless he has given the prior consent to act. Means when the LLP submit the documents to the register of companies, that's why this person will be the designated partner. The consent of that partner should also be there. LLP ने तो नोट दिया कि भैया आप बन जाओ इंडिया के पार्टनर, वो पार्टनर तैयार ही नहीं है. So that law says the prior consent of the person who is willing to be a designated partner should be submitted to the ROC. सर इफ चूज ही नहीं किया ना, ये तो मेंशन करना पड़ेगा बच्चे, तो रिक्वायरमेंट ऑफ लॉ है. Every LLP shall file with the registrar the particulars of every individual who has given his consent to act as designated partner in such form and such manner as prescribed by the rules within 30 days of his appointment. Right? 30 दिन के अंदर सबमिट करनी है आरओसी को. An individual eligible to be designated partner shall satisfy such condition as may be prescribed by the rules, and every designated partner shall obtain a DPIN from central government, and the provisions of section 153 to 159 of the Companies Act 2013 shall apply mutatis mutandis for the said purpose. What do you mean by mutatis mutandis? Means as it is. The provision will as it is apply to the matter relating to the designated partner identification number DPIN. Actually, mutandis एक शब्द है as it is. If you have watched the movie, I think no one of you has watched a very old movie, Arju. So the great Mahmood sir is says in that movie, and on every sentence of the star Rajendra Kumar, mutandis babuji, mutandis. Mutandis means as it is. वो जो कह रहे हैं सब वही. हाँ सही है, सब बिल्कुल सही है आपके अकॉर्डिंग. राइट. So any doubt in section number 7? अभी लोग बोल नहीं रहे, डाउट सारे क्लियर हो गए हैं आपके, मेरे हिसाब, आप लोगों के हिसाब से. आपके अभी जब सुपर ओवर आएगा तब देखना, तब सबको सही आंसर देने, फिर गलत मत देना. आई एम एक्सपेक्टिंग यू, क्योंकि बिकॉज अभी some of you have said that we have read this LLP in foundation also. Okay. Sir, designated partner choose करना compulsory? Yes. Because law says that at least 2 individuals should be designated partners. Unless section 8 provides the liabilities of designated partners. It says, unless expressly provided otherwise in this act, a designated partner shall be responsible for doing all acts, matter and things as are required to be done by LLP in respect of compliance of the provisions of this act, including filing of any document, written statement and like report pursuant to the provisions of the act as may be specified in the LLP. सारे काम के लिए लाइबल है जो उसको दिए गए, and liable to all penalties imposed on the LLP for any contravention of those provisions. What are those penalties? Section 9, change in the designated partner. If LLP has right to change the designated partner, LLP may appoint a designated partner within 30 days of vacancy. जिस दिन चला गया छोड़ के उसके 30 दिन के अंदर आपको नया अपॉइंट करना है. For any reason, and provisions of section 7, subsection 4 and subsection 5 shall apply in respect of such new designated partner. So come to the point number subsection 4 and subsection 5 क्या थे ये देखिए. Subsection 4, every LLP shall file registrar the particulars of every individual. जब नया आएगा तो उसकी आपको इन्फॉर्मेशन देनी है. ये सबसेक्शन 4 हो गया. Subsection 5, individual have to satisfy all the condition as required for a person being an designated partner. Right? These are the penalties, punishment for contravention of section 7 and 8, and these are given in section number 10. If LLP contravenes the provisions of section 7 subsection 1, that is number of designated partner less than 2, or none of the designated partner is a resident in India, penalty on LLP 10,000 plus 100 per day subject to maximum 1 lakh, and on every partner is also liable, each and every partner including designated partner. Penalty of rupees 10,000 plus 100 per day subject to maximum 50,000. If the LLP contravenes the provisions of section 7 subsection 4, what is that section? Failure to file the consent of appointment of designated partner within 30 days of his appointment, then LLP will be liable for penalty 5,000 plus 100 rupees per day subject to maximum 50,000. For every designated partner, penalty of rupees 5,000 plus 100 per day subject to maximum 25,000. If LLP contravenes the provisions of section 7, subsection 5 and section 9, then LLP will be liable for the penalty of 10,000 minimum penalty plus 100 rupees per day subject to maximum 1 lakh, and for every partner including designated partner penalty of 10,000 plus 100 rupees per day subject to maximum 50,000. एक बार ध्यान से पढ़ लो, मैं कुछ 1 मिनट दे रहा हूँ, पढ़ो ध्यान से बच्चों. Sir, but the payment of such penalty will be made from LLP account. No, penalty will be, देखिए लिखा हुआ, it was clearly mentioned. A penalty will be paid by the LLP also and partner their from their own pocket, right? Someone has asked me, sir, what is section 5 and 9? क्या बात कर रहे हो दोस्त, क्लास में रहो भाई. This is section subsection 5. This is section 9. Someone has asked me, sir, please repeat example number 3. There is an LLP by the name Indian Helicopter. कहता LLP थी Indian Helicopter के नाम से, and 5 partners, Mr. A, Mr. B, Miss C, Miss D, Miss E, in which Mr. A and B are non-resident, but C, D, E and resident. So the example says that at least one should be a resident. So if, because A and B both are non-resident, so only those cannot be a resident partner. One should be from CDE, should be from CDE, should be a designated partner, right? और कोई query? Sir, I am asking regarding the liability, designated partner's liability. Designated partner have to pay from his own pocket, right, beta? So let's start the penalty shootout. करें क्या बच्चों, बताओ फटाफट से. After that we will have the break of 5 minutes. Okay, चलिए. First question. When did LLP Act 2008 come into force? Answer should be in one shot. एक बार में भेजने सारे. Sir, 30 days after not appoint DP when all partners deemed to be LLP. Designated partner no, ऐसा नहीं होता. Next question. LLP shall be governed by the provisions of Companies Act 2013, LLP Act 2008, Cooperative Society Act 1912, Indian Partnership Act 1932. LLP is not a separate entity from that of its partners, a legal entity separate from that of its partners, body corporate. Only B and C are correct. Next question. Which section of LLP Act 2008 deals with the minimum number of partners? 7, 4, 6, 9. Whether a HUF can become a partner LLP. HUF may become a partner of LLP provided the registrar may grant the permission in this behalf. No, HUF can't become a partner in LLP. HUF may become partner of LLP, none of the above. How many designated partners are required in LLP? At least 2 designated partners, 7 designated partners, 2 designated partners, at least 7 designated partners. So these were the questions. I'm just waiting for your answers that I will discuss. When LLP Act came into force, ये तो मैंने सबसे पहली स्लाइड में बताया था, उसके बाद भी गलती करी हो तो बड़ा खतरनाक काम हो जाएगा. This is 31st March 2009. Governed by the LLP Act 2008. A limited liability partnership, legal separate and from its partners and body corporate. So only B and C are correct. Section number 6. No, HUF cannot be a partner. At least 2 designated partners. At least 2. Let's check who has given all the correct answers. First one is Mr. Nayan Patil. Congratulations बच्चे. अपूर्व सर सेकंड क्वेश्चन शो कर दीजिए, बताता हूँ बच्चे मेरे, वेट करो. तांबेश्वरी कांग्रेचुलेशन. नैन्सी कांग्रेचुलेशन. अंजलि कांग्रेचुलेशन. नंदा गोपाल कांग्रेचुलेशन. पल्लवी कांग्रेचुलेशन. जब तक सेकंड क्वेश्चन देखिए बच्चे आप. एंड दिस साइड. ओके, so these were the questions of penalty shootout. Now at this place we are having a break of 5 minutes. 5 मिनट्स के बाद मिलते हैं दोबारा. मनीष जी 5 मिनट का ब्रेक दीजिए बच्चों को. ओके. Yes, thank you. So now come to the incorporation of LLP. Incorporation of LLP. Section 11 provides the procedure. What are the requirements for incorporation of what documents are required for incorporation of the LLP? Subsection 1 provides two or more persons associated for carrying on a lawful business with a profit motive shall subscribe their name to an incorporation document. Means they have to at least 2% should be there who will give the name, to the incorporation document. After the incorporation, these two, at least 2% will be the partners of LLP, and they are called subscriber to the LLP. Filing of document section clause B provides the incorporation document shall be filed with the register of state in which registered office of LLP is to be situated with the prescribed fee. Incorporation documents are now processed electronically by Registrar Central Registration Center since 2nd October 2018. ऑनलाइन सिस्टम चालू हो गया, डॉक्यूमेंट सबमिट करने आरओसी को विद द प्रिस्क्राइब्ड फीस. Compliance statement. Clause C provides a compliance statement in the prescribed form. Prescribed form means the form as prescribed by the rules of LLP. Shall be filed with the ROC with the incorporation document, which shall be certified, which shall be authorized, yeah, which can be signed by one professional and one out of those persons who will be the partners of LLP. यानी एक घर का बंदा और एक बाहर का. And that professional can be an advocate, can be a company secretary, can be a chartered accountant, can be a CWA. CWA means cost work accountant, who is engaged in the formation of LLP and by anyone who subscribe his name to the incorporation document. Means a document is compliance statement is signed either one person out of these professional, advocate, company secretary, chartered accountant or CWA, and anyone who subscribe his name to the incorporation document, stating that. And what is the purpose of this compliance statement? That to state that all the requirements of the act and the rules made thereunder have been complied with regard to the incorporation of the incorporation and matter precedent and incidental. क्या मतलब बच्चों इसका कि भाई आरओसी कह रहा है कि मैं कहां तक डॉक्यूमेंट चेक करूंगा खुद जाके. ये एक घर का मेंबर सर्टिफाई कर दे और एक बाहर का प्रोफेशनल कि भैया हाँ जो द रिक्वायरमेंट ऑल द रिक्वायरमेंट विच शुड बी फॉर द इनकॉर्पोरेशन ऑफ एलएलपी हैव बीन कंप्लाइड. तो रिस्पॉन्सिबिलिटी वो आपके ऊपर डाल. What are the contents of incorporation documents? The form should prescribe form, and that contain the name of LLP, proposed business of LLP, address of the registered office of LLP, name and address of each of the person who are to be the partner of LLP, name and address of the person who are to be designated partner of LLP, and contains such other information concerning the proposed LLP as may be prescribed. Right? पढ़ लीजिए एक बार. फाइन फॉर मेकिंग फॉल्स कंप्लायंस, यानी कि आपने झूठा स्टेटमेंट दिया. फॉल्स इफ द एनी if anything is false in the compliance statement, then signing person will be liable for imprisonment up to 2 years and fine minimum 10,000, which may be to up to the 5 lakh. So if a person makes a statement as discussed above which he knows to be false or does not believe it to be true, shall be punishable with imprisonment up to 2 years and with fine up to minimum 10,000 to 5 lakh. After incorporation, the registrar shall maintain a register of LLPs in which the names of LLP shall be entered in order in which they are registered. Every LLP so registered shall be assigned a LLPI in one consecutive field. एक नंबर मिल जाएगा, इसे हम क्या बोलेंगे, LLP identification. Please read it and tell me if any doubt on section 11. Sir, so those person who act as professional and give compliance report have to pay the penalty. Yes, if the information which is in the incorporating document is found false, then they will be liable. Now, section 12, incorporation by registration. Now, role of registrar. When the requirement of section 11 have been complied with, means all the documents as required by section 11 have been submitted to the ROC, the ROC shall retain those documents and within 14 days from the date of submission, register the incorporation and give a certificate that the LLP is incorporated by the name specified there. Compliance statement. The compliance statement which is delivered by the LLP at that with the documents which are mentioned section 11, it is sufficient evidence on which ROC can rely that the requirement as to subscription name have been properly complied. सर इज इट रजिस्टर्ड विद आरओसी और रजिस्टर ऑफ फर्म? अरे बच्चे मेरे सब फर्स्ट स्टार्टिंग में बोला था इट इज रजिस्टर्ड विद द आरओसी नॉट रजिस्टर ऑफ फर्म. रजिस्टर ऑफ फर्म्स आर कनेक्टेड विद द पार्टनरशिप एक्ट. Significance of certificate. What is the significance of certificate? The certificate shall be issued. The certificate issued shall be the signed by the registrar, means registrar of companies, and that will be authenticated by the official seal of the government. And that certificate is the conclusive evidence that LLP is incorporated by the name which is mentioned on that certificate. Any doubt in section number 12? बोलो बच्चों. Now, section 13, registered office of LLP and change in that registered office. So, every LLP shall have a registered office to which all communication notices may be addressed and where they shall be received. A document may be served on LLP or partner or designated partner thereof by sending it by post under a certificate of posting or by registered post or by any other prescribed manner at the registered office and any other address specifically declared by LLP for the purpose in the prescribed form and manner. पढ़िए दोबारा इसको एक बार. A document may be served on LLP or a partner, that is partner at by registered post. यानी रजिस्टर्ड पोस्ट पे आपने भेज दिया, उसके जो एड्रेस में प्रोवाइड किया हुआ है, इट मींस इट इज प्रॉपर्ली सर्व्ड. Email is also valid, yes. LLP may change the place of registered office and file the notice of such change with the registrar, that is ROC, in such form and manner and subject to such condition as may be prescribed, and any such change shall take effect only upon such file. If LLP contravenes any provision of this section, the LLP and its every partner shall be punishable with penalty of 500 per day up to rupees 50,000. सर पॉइंट नंबर 2 को हिंदी में समझा दो. अरे मेरे लाल. डॉक्यूमेंट कोई भेजना है आरओसी को, किसी एलएलपी को, पार्टनर को, डेजिग्नेटेड पार्टनर को, तो जो उसने एड्रेस अपना प्रोवाइड किया है उस पे हमें बाई पोस्ट यानी बाई रजिस्टर्ड पोस्ट अगर भेजते हैं या अंडर यूपीसी भेजते हैं, अंडर सर्टिफिकेट ऑफ पोस्टिंग भेजते हैं, तो ये माना जाएगा प्रॉपरली पहुंच गया है उसके पास। ठीक है, अभी क्लियर हुआ क्या? Effect of registration. Now LLP is already registered. So what are the effect of such registration? On registration, LLP shall by its name be capable of suing and being sued. यानी कि after registration it becomes the separate legal entity. It becomes an person, artificial legal person. It can sue and being sued. Acquiring, owning, holding and developing or disposing of property, whether movable or immovable, tangible or intangible. It is having a common seal if it decides to have one, and doing and suffering such other acts and things as body corporate may lawfully do or suffer. वो सारे काम कर सकती है जो कोई इंसान कर सकता है। पढ़िए बच्चों। Now section 15, name. Any doubt up to this point? समझ आ रहा है ना बच्चों? Please, my future chartered accountants. Sir, if CS is appointed in LLP, can one CS and designated partner can also sign official document? No, I am talking about the compliance statement that CS can be that CS can sign. Name. Every LLP shall have either the word LLP or the acronym LLP as the last word of its name. यानी कि नाम के एंड में लिमिटेड लाइबिलिटी पार्टनरशिप लगाना है या LLP शब्द को यूज करना है। No LLP shall be registered by the name which in the opinion of central government is undesirable or identical or too nearly resemble to that of other LLP or company or registered trade. यानी कि अगर सेंट्रल गवर्नमेंट को लगता है ये नाम यार नहीं एक्सेप्टेबल नहीं है, कुछ अलग गड़बड़ लग रहा है, या फिर वो किसी और एलएलपी या कंपनी या रजिस्टर्ड ट्रेडमार्क से मैच करता है, तो वो दैट नेम कैन नॉट बी अलाउड टू एलएलपी टू बी इनकॉर्पोरेटेड। Now reservation of name section 16 provides, suppose what is the meaning कि suppose मुझे लगता है कि I could start the business after 3 months only because there's some technical problems, some fund problems I am arranging for that, but the name should be final. So in that case, the person can take the reservation of name by providing the prescribed fees. So section 16 provides a person may apply in the prescribed form and manner as provided by rules with fees to the registrar for the reservation of name set out in the application as name of the proposed LLP or name to which a LLP proposes to change its name. यानी कि प्रपोज नई एलएलपी बन रही है तो उसका नाम रिजर्व कर सकते हैं, या मैं एलएलपी आई हैव एन एग्जिस्टिंग एलएलपी एंड आई वांट टू चेंज इट्स नेम आफ्टर सम टाइम, आई कैन टेक द रिजर्वेशन ऑफ दैट नेम. Upon receipt of an application or payment of the prescribed fee, the registrar may, if he is satisfied, subject to the rules prescribed by central government in the matter that the name to be reserved is not one which may be rejected on any ground referred to in subsection 2 of section 15. Reserve the name for a period of 3 months from the date of intimation by the registrar. यानी कि आप जब फीस पे करेंगे और नाम ने जो सेक्शन 15 की कंडीशन है वो फुलफिल करता है, तो दैट नेम कैन बी रिजर्व फॉर 3 मंथ फ्रॉम द डेट ऑफ इशू ऑफ ऑर्डर बाय द आरओसी. जिस दिन आरओसी अलाउ करेगा आपको रिजर्व करने के लिए, उससे 3 महीने के अंदर 3 महीने तक आप नाम को होल्ड कर सकते हैं, 3 महीने के अंदर उस नाम को यूज कर सकते हैं अपने एलएलपी बनाने. नाउ चेंज ऑफ नेम ऑफ एलएलपी सेक्शन 17. इफ द नेम ऑफ LLP इज आइडेंटिकल, एक मिनट जाते हैं, चलिए पहले यहाँ तक कन्वर्ट करते हैं। सेक्शन 17 स्टार्ट करने से पहले आप क्वेरी बताइए। इफ यू हैव एनी क्वेरी रिगार्डिंग सेक्शन 15, 16, प्लीज टेल मी, आई एम जस्ट वेटिंग फॉर योर क्वेरी, प्लीज टेल मी बच्चों, अगर कोई क्वेरी है तो बताइए। सर 3 महीने के बाद नाम चेंज करना है। देखिए द नेम इज रिजर्व इनिशियली फॉर 3 months, and if you could not work on that name within 3 months, so you can file and you can deposit additional fees for increasing the term as per the decision of ROC. Section 16 का point number 2. Okay, let's, upon receipt of an application, application for what? Application for reservation of name, and on payment of the prescribed fee, the registrar may, if is satisfied, तो ठीक है, ऑल द सेक्शन 15 की जो रिक्वायरमेंट है वो पूरी हो गई। व्हाट इज सेक्शन 15? Subsection 2, the name should not be undesirable, name should not be identical or too nearly resemble to the LLP, company or registered trademark, right? So then in that case, the ROC may allow to reserve the name for 3 months. 3 महीने तक वो नाम आपका रिजर्व रहेगा, 3 महीने तक आपको यूज कर सकते हैं, 3 महीने के बाद वो नाम फ्री हो जाएगा, फिर कोई और यूज कर सकता है। बट you can file the request, you can file the application for by additional fees for increasing that term also। 3 महीने और बढ़वा सकते हैं फीस अगर टाइम देकर। नाउ एनी डाउट? अरे कुछ तो बोलो बच्चों। क्लियर हो गया। नाउ सेक्शन 17, चेंज ऑफ नेम। अब यू वांट टू, द LLP वांट टू चेंज इट्स नेम, so that if the name mutually or other condition क्या है, if the name of LLP is identical with or too nearly resembles to that of any other LLP or a company or registered trademark of a proprietor under Trademark Act 1999, then on the application of such LLP or proprietor referred to in clause A and B respectively or a company, the central government may direct that such LLP to change its name within a period of 3 months from the date of issue of such direction। क्या है? After incorporation of LLP, it was found the name of LLP is resembles with that of any other LLP or company or the registered trademark, then on such application, previous old wali, then on the application of old LLP, proprietor or company, the central government may give the direction to the new LLP to change its name within a period of 3 months। एक LLP बन जाती है, बाद में मालूम पड़ता है यार इसका नाम तो किसी पुरानी LLP से या कंपनी से या किसी रजिस्टर्ड ट्रेडमार्क से मैच करता है, और वो जो पुरानी LLP है या कंपनी है या रजिस्टर्ड ट्रेडमार्क है, वो एप्लीकेशन देते हैं ROC को, साहब देखो ये नई बनी है LLP, इसका नाम हमारी LLP से मैच, हमारी फर्म से या ट्रेडमार्क से या कंपनी से मैच कर रहा है। इन दैट केस सेंट्रल गवर्नमेंट विल गिव द डायरेक्शन कि भैया LLP तुम्हारा नाम मैच कर रहा है पुरानी वाली से, तुम अपना नाम चेंज करो, provided that an application to the proprietor of the registered trademark shall be maintainable with a period of 3 years from the date of incorporation, registration or change of name of LLP under this। लेकिन एक कंडीशन दी गई, registered trademark, the proprietor having registered trademark which is resemble with the LLP is allowed to make the application within 3 years only from the date of incorporation of new LLP। ये जो LLP बनी है उसका नाम अगर आपके रजिस्टर्ड ट्रेडमार्क से मैच कर रहा है तो आपको 3 साल दिए जाते हैं, उसके अंदर आपको ये एप्लीकेशन देनी है कि भैया चेंज कर लो। 3 साल के बाद आपकी एप्लीकेशन मेंटेन नहीं की जाएगी, सुनी नहीं जाएगी। एनी डाउट इन पॉइंट नंबर 1 सेक्शन 17? प्रोवाइडेड दैट, क्या है प्रोवाइडेड में? एन एप्लीकेशन ऑफ द प्रोप्राइटर ऑफ द रजिस्टर्ड ट्रेडमार्क शैल बी मेंटेनेबल within a period of 3 years from the date of incorporation, registration or change of name of LLP under this act. Means only in case of registered trademark, if the proprietor thinks that its name is the name of registered trademark is matching with the name of LLP, so he is allowed 3 years only to make the application to ROC for the change of the name of LLP. अगर किसी रजिस्टर्ड ट्रेडमार्क के प्रोप्राइटर को मालूम पड़ता है यार ये तो मेरी हमारा जो नाम है ना रजिस्टर्ड ट्रेडमार्क का वो तो एलएलपी से मैच कर रहा है, जो बाद में एलएलपी बनी है, उसको 3 साल दिए जाते हैं कि 3 साल के अंदर आप एप्लीकेशन फाइल कर दीजिए, 3 साल के बाद आपकी एप्लीकेशन कंसिडर नहीं की जाएगी। सर सेंट्रल गवर्नमेंट विल डायरेक्शन विद इन 3 months आफ्टर रिसीट ऑफ द दिस डायरेक्शन 3 years इज गिवन फॉर एलएलपी टू चेंज इट्स नेम। नहीं, कंफ्यूज हो रहे हैं आप जिस दिन एप्लीकेशन देंगे उसके बाद सेंट्रल गवर्नमेंट ऑर्डर करेगी चेंज करने के लिए, एंड when the central government make the order and it will provide 3 months. For example, you have made the application on 1st December for change, and central government makes the order for change within 15 on 15th December, then 3 months will be from 15th December, right? कंफ्यूज हो रहे हैं? तांबेश्वरी क्लियर हुआ कि नहीं हुआ? ट्रेडमार्क होल्डर should file the suit with ROC within 3 years. Yes, okay. Sir, LLP can change its name suo moto. Yes, but the condition of section 15 subsection 2 should be there. चेंज कर सकते हैं, बिल्कुल कर सकते हैं, नॉर्मल वे में कर सकते हैं, बट कंडीशन आपको जो 15(2) की कंडीशन है वो आपको फॉलो करनी पड़ेगी। एनीथिंग एल्स? सर देखिए प्लीज लिसन, LLP wants to change its name, okay, you can change, फ्री हुआ भैया, चेंज कर दो नाम, बट if name of LLP is identical with that of any other LLP company or registered trademark, then on the application of these LLP company or trademark, the ROC, the central government may order for the change, and that change should be within 3 months from the date of order by central government. Time for application, no limit for company and LLP. Limit is applicable only for the proprietor of registered trademark, and he or she can file the application for change only within 3 years only, and after that if he make the application, that not be maintainable, that not be considerable. अब बताओ क्लियर हुआ कि नहीं हुआ? LLP shall within a period of 15 days give notice of the change to registrar along with the order of central government, who shall carry out necessary change in certificate of incorporation, and within 30 days of such change in the certificate of incorporation, such LLP shall change its name in the LLP agreement. It means LLP shall within a period of 15 days give notice of the change to ROC, यानी जिस दिन LLP नाम चेंज करेगी एंड उसके 15 दिन के अंदर ROC को इन्फॉर्म करेगी कि भैया हमने नाम चेंज कर दिया। Who shall carry out necessary changes in the certificate of incorporation, and after that ROC will change the certificate of incorporation, will issue the certificate of incorporation with new name, and after issuing the certificate with new name, in 30 days, in next 30 days, the LLP change the name in the LLP agreement. If the LLP is a default in complying with the direction of given in the section 1, subsection 1, the central government shall allot a new name to LLP and the registrar shall enter the new name in the register of LLP in place of old name and issue a fresh certificate of incorporation with the new name. What is saying? If a direction was given to LLP for change of name, but LLP has not changed the name, 3 महीने में change ही नहीं किया, the central government has the power to give a new name automatically. हम नया नाम देने मत जाओ, और यही नाम तुम्हें रहेगा, उसके बाद तुम सर्टिफिकेट LLP न्यू सर्टिफिकेट ऑफ incorporation with new name will be given to that LLP. Sir, whether LLP after receiving this new name which is already given by central government can change the name? Yes. कि अब LLP को डायरेक्शन दिए गए 3 महीने में नाम चेंज करने के लिए, उसने नाम चेंज नहीं किया, सेंट्रल गवर्नमेंट को लगा ये चेंज नहीं कर रहे हो, नया नाम दे दिया, अब वो नाम LLP पसंद नहीं आ रहा है, दे तो दिया, पसंद नहीं आ रहा है, क्या LLP चेंज कर सकती है? द आंसर इज यस. So provided that nothing contained in this subsection shall prevent a LLP from subsequently changing its name, right? Any doubt? बताओ भाई, क्योंकि आज आप बहुत थके हुए हो, लास्ट सेशन है, जल्दी खत्म करने की कोशिश करेंगे, मतलब आपको बोर नहीं होना चाहिए, थोड़ा सा ही रह गया है. LLP हुई then it can make application anytime. Yes, LLP can no time limit for making application by LLP for change of name. भाई LLP एक LLP बनी, बाद में एक पुरानी LLP को मालूम पड़ा कि भाई इस नाम से LLP बन गई है, हमारे नाम से मैच कर रही है, तो क्या किया उन्होंने? आप चेंज पुरानी LLP की लाइबिलिटी के आरोपी को इन्फॉर्म करें, रिस्पॉन्सिबिलिटी के आरोपी को इन्फॉर्म करें, भैया हमारा ये हमारा नाम पहले से लिया हुआ है, ये नई बन गई है, चेंज करा दो, पर इसकी कोई टाइम लिमिट नहीं दी गई है, राइट? एनीथिंग एल्स? तो व्हाट आर द स्टेप? देखो, रिजर्वेशन ऑफ नेम ऑफ LLP, इसके लिए नया फॉर्म आ गया, न्यू फॉर्म इज द रन LLP which is available on the MCA site, and for registration of LLP it is flip form, and LLP agreement is mandatory for section as per section 23 of the act, and it will be filed in form number 3, that is within 30 days of incorporation of LLP. तो ये तो आज का पार्ट हो गया. अभी तक कोई डाउट हो तो बताओ मुझे, फिर हम सुपर ओवर या पेनल्टी शूट आउट स्टार्ट करते हैं. So whether we should start penalty shootout too? After this penalty shootout, we will have a fast revision for what we have discussed today. Right. यहाँ तक everything is clear up to this point? Please tell me. लेट्स स्टार्ट. बताइए भैया, बच्चों बोलो, कुछ स्टार्ट करें क्या? कोई क्वेरी तो नहीं है? प्लीज, क्लियर है कि नहीं है? ठीक है, चलिए. फर्स्ट क्वेश्चन, The incorporation document shall be in run LLP, flip, any of the above, none of the above. आंसर सारे एक साथ भेजिए. When the requirement of section 11 has been complied with, the registrar shall give the incorporation certificate within 7 days, 10 days, 14 days, 30 days. Fine for making false compliance statement under section 11, 1,000 to 1 lakh, 10,000 to 5 lakh, 10,000 to 10 lakh, none of the above. Section 12 of LLP Act 2008 deals with incorporation by registration, LLP to be body corporate, reservation of name, partner as agent. Which form is filed for reservation of name? Run LLP, flip, any of the above, none of the above. Central government may direct such LLP to change its name, and LLP shall comply with the said direction within 1 month, 3 months, 6 months, 9 months after the date of direction of such longer period as central government may allow. चेक करते हैं बच्चों, आप लोग आंसर कीजिए. Incorporation in form flip. $14 days. $10,000 to 5 lakh rupees. Section 12 for incorporation by registration. Reservation, run LLP. Reservation of name, run LLP. And within 3 months. So let's check. हार्दिक मरवा, कॉन्ग्रेचुलेशन बच्चे. Nanda Gopal, congratulations. Ritika Gupta, congratulations. Manvi, congratulations. Nancy, congratulations बच्चे. Pallavi, congratulations. तो दिस वॉज फॉर टुडे. बस एक फास्ट रिवीजन लेते हैं फटाफट से ताकि आप जल्दी से फ्री हो जाओ. फास्ट रिवीजन लेते हैं. व्हाट वी हैव डिस्कस टुडे. Applicability. The Act is applicable with effect from 31st March 2009 in extent whole of India. It has 81 section and 4 schedules. Schedule First schedule is for mutual rights and duties of partners. Second schedule, conversion of firm into LLP. Third schedule of conversion of private company to LLP. Fourth schedule, conversion of unlisted public company into LLP. Provisions of Indian Partnership Act 1932 will not be applicable. Concept, meaning and concept LLP. LLP is a new form of legal business entities, separate legal entity and limited liability of partners. It is an alternative corporate business form that gives the benefits of limited liability of company and the flexibility of partnership. Section 5 deals with the partners. An individual or body corporate may be a partner in LLP, but not a person of unsound mind, undischarged insolvent, or the person who has applied to be adjudicated as an insolvent. Minimum number of partners, section 6, 2 partners. If LLP carries on the business for more than 6 months with only one partner, and he shall be liable personally if he knows the fact for the obligation of LLP incurred during that period. Body corporate definition, section 2, clause D. A company and includes LLP, foreign company, but does not include corporation, sole proprietorship, corporate societies, or any other body corporate which is specifically excluded by central government. Business includes every trade, profession, service, and occupation except any activity which the central government may by notification exclude. Designated partner, any partner designated as such pursuant to section 7. Entity, any body corporate includes a firm for a specific section. Foreign LLP which is incorporated form registered outside India having a place of business in India. Financial year normally 1st April to 31st March, but if LLP incorporated after 30th September, financial may end on the 31st day of March of the next following that year. LLP partnership form registered under this act. LLP agreement, written agreement between the partners of LLP or between the LLP and its partners. Partners, any person who becomes partner in accordance with the LLP agreement. A small LLP contribution up to 25 lakhs or with such higher as prescribed, up to the 5 crore, and turnover is up for the immediately preceding financial year up to 40 lakhs or such higher amount as prescribed but up to 50 crore rupees, or which fulfills other such terms and conditions as may be prescribed. Designated partner, at least 2 individuals should be designated partners. One of them should be resident in India. Resident in India means a person who has stayed in India for a period of not less than 120 days during the immediately preceding 1 year. Characteristics of LLP, almost that same that of the company. LLP is body corporate, it has perpetual succession, it has separate legal entity. The liability of partners is limited up to the amount of contribution. The mutual agreement. LLP is formed as per the agreement. Minimum maximum number of partners, minimum 2, maximum no limit. Business should be for profit only, not for the charitable purpose. It is an artificial legal person. It has common seal. Management of business by all the partners. Conversion of into LLP यानी कि partner firm a private company and unlisted public company can be converted into LLP. Investigation power are given as per the Partnership Act, as per the LLP Act. Compromise or arrangement as per the LLP Act. For an LLP can be the partner, and documents are e-filed on the portal. What are the advantage of LLP? Easy to form. LLP agreement can be customized, can be changed as per the requirement. Operates on the base of agreement, no minimum capital requirement, less compliance and tax burden as compared to the company, flexibility regarding the increase in the funds, limited liability of the partners, and dissolution procedure are easy as compared to the company. Incorporation of LLP, subscription of name by 2 or more persons, filing of document with registrar with the prescribed fees, compliance statement prescribed form made by either an advocate, company secretary, chartered accountant, cost and work accountant, and any one of the person who subscribes name. Contents of incorporation document: name, proposed business, address of LLP, name and address of each of the to be partners and derivative partners, other prescribed information. Issue of incorporation certificate by the registrar within 14 days of submission of documents. Registered office and change herein. Every LLP shall have a registered office. A document may be served by sending it by post at the registered office and any other address specifically declared for communication. In case of change of place of office, registered office, notice should be to ROC. If contravenes in the provision, penalty on LLP and every partner 500 rupees each day, subject to maximum 50,000. Name: the use of words limited liability partnership or LLP as the last words of the name. No LLP registration by name which in the opinion of central government is undesirable or identical or too nearly resemble to any other partnership firm or LLP or company or registered trademark. Change of name: if the name of registered LLP is identical or too nearly resembles to any other partnership firm or LLP or a company or registered trademark, central government may direct such LLP to change its name within 3 months, but on application. Reservation of name: file e-form 2 नहीं आएगा, file flip form for incorporation, execution of LLP agreement within 30 days of incorporation. So this was the revision of what we have discussed in the last 2 hours. So if any of you have any doubt, you can ask me. Otherwise, we will end the today's session, and in the next session, that is on I think 13th. We will 13th on Monday. We will finish the rest part of the LLP. So I think, please, my request, my humble request to all of you, please should get revised just after the class. आधा घंटा लगेगा, रिवाइज कर लीजिए, सेट हो जाएगा दिमाग में. ठीक है? Thank you so much, everyone. Thank you for your patient hearing. Sir, what is the weightage of this chapter? I will discuss in the next class. ठीक है? Thank you, everyone. Manish sir, are you there? The class is over now. You can leave. Stop the class. ठीक है sir? Thank you.